This short video has been designed to provide receptionists and administrators with an overview of the GDPR and what it means in general practice. GDPR stands for General Data Protection Regulation, which came into effect on the 25th of May 2018 and was applicable as law in the UK from this date. The GDPR was introduced to harmonise data privacy laws throughout the EU, giving individuals or data subjects, as they are referred to in the regulation, more rights when it comes to the processing of their personal data. For detailed information about the regulation, take a look on the ICO website, which is the Information Commissioner's Office website, ico.org.uk. So what does the regulation mean to you as a receptionist or administrator? Well, you've probably had countless emails about the GDPR, and so have your patients. But it's your patients who may want to know more, so you should be prepared. We'll start by taking a look at some of the terminology used in the regulation. We'll begin with data controllers. This will usually be your practice, unless the partners decide to nominate an individual to act as a controller. But as a controller, the practice has a duty to ensure that personal data at your practice is processed appropriately and should be able to demonstrate compliance with the regulation. Next, there are data processors. These are individuals or organisations who are responsible for the processing of personal data on behalf of data controllers. So, in general practice, that is anyone who processes an individual's personal data. As a processor, you have legal obligations, such as maintaining records of personal data and the associated processing activities. You'll be legally liable if you're responsible for a data breach. But don't worry, because if you've been compliant with the Data Protection Act, the Caldecott Principles and other legislation, then there isn't a lot that has changed. But if you want to learn more, take a look at Article 5 of the GDPR, which explains the processing activities in much more detail. So, what do we mean by the term personal data? Well, personal data is any information which relates to the data subject. This can be name, address, telephone number, patient ID, the list goes on. And when we talk about processing, we mean any action performed on that personal data. That can be manually or in an automated process. Personal data must be processed lawfully, fairly and transparently, collected only for specific legitimate purposes, adequate, relevant and limited to what is necessary, accurate and up to date, stored only for as long as necessary, and those involved with the data must ensure appropriate security, integrity and confidentiality of the data. In doing so, your practice will be demonstrating compliance with the data protection principles set out in the GDPR. Now let's turn our focus to the patient. Do your patients know how the GDPR affects them? What their rights are? The changes to accessing their data? They have a right to know how it is being processed and to ensure it is being processed lawfully and fairly. Well, if someone had your data, you want to know that too, right? If patients are uncertain, they could take a look at your practice privacy notice, which should have been updated to become GDPR compliant. What does that mean? Okay, to be compliant, your practice privacy notice must be concise, transparent, and easily accessible, written in clear and plain language, particularly if addressed to a child. It must explain what information is collected, how that information is being used, how confidentiality is maintained and how patients access their records, cover risk stratification, invoice validation, who pays for the treatment, opt-outs, which relates to the National Data Opt-out Programme, retention periods, how long patient data is kept, what patients should do if they have any questions, the complaints process, and any changes to the practice privacy policy. So that's how the changes are made and when they'll be published. One thing that has changed, and I'm sure you've all heard about it, is the way in which subject access requests are now processed. Firstly, you'll probably know that you cannot charge an individual or a third party, such as a solicitor, if they're acting on behalf of the patient, when requesting a copy of the patient's medical records. The practice must respond to such requests within 1 calendar month. but this may be extended by 2 months if the request is complex or you have a large volume of requests. You'll also need to make sure you check the person requesting the information is the data subject or has the consent of the data subject, and you can do this by verifying their ID. And it is also acceptable to ask the data subject for evidence of their identity. Your practice should have an access to medical records policy which outlines the SAR process. Something else which you may have heard of is the right to erasure, and that's not the 80s pop group, but it's something that is also referred to as the right to be forgotten. And this is where an individual can request to have certain data erased. But on that note, the British Medical Association have stated that in healthcare it is highly unlikely that this right would apply, say for instances of unlawful processing of personal data. If requests for data to be erased or amended are received, the original record must be retained for audit purposes. Detailed information about this particular right can also be found on the ICO website, and it is in Article 17 of the GDPR. Okay, so the last thing I want to talk about is data breaches. Data breaches could be unauthorized third-party access to data, loss of personal data, amending a data subject's personal data without their permission, the loss of IT equipment, or personal data being sent to the incorrect recipient. And there are many more. So if there's a data breach, it must be reported without undue delay or within 72 hours of the breach being identified. But who do you report it to? Well, this is to be dealt with on a case-by-case basis, as not all data breaches require the practice to inform the Information Commissioner's Office. But every breach, no matter how minor, must be recorded. Your practice should have a log where all data breaches are recorded and all actions taken to resolve the breach. Your practice manager will be able to explain who in your practice data breaches are to be reported to. There's also a requirement to inform the data subject about the breach. They should be given time to take any necessary steps to protect themselves from the effects of a data breach. Your practice must ensure they are given full facts about the breach, explaining who the data subject must contact if they have a query, what actions have been taken so far, and given any other relevant information. Most importantly, don't ever hide a breach. If it needs to be reported, make sure you do. Organisations can face a fine of up to €10 million if they hide a breach. And again, further information and guidance is available from the Information Commissioner's Office. Okay, that was a short overview of the regulation, hopefully enabling you to understand why it is important to ensure your daily activities in your practice are affected by the GDPR and what you must do to ensure compliance with the regulation. If you've got any questions, there's a GDPR forum on the Practice Index website where you can ask questions, and I'll do my best to answer them for you. Thanks for watching.